Learned counsel has argued that after order dated 10th March 2017 was passed this court in case number 70 of 2017, PW 21, Rajneesh Mohan Singh was examined in the criminal case. He categorically stated in paragraph number 13 of his statement that in the file, the Honorable Finance Minister had nowhere given sanction to prosecute the petitioner. It gave a fresh cause of action to petitioner to further file an application for dropping the proceedings of criminal case. It is argued that till the examination of PW 21 Rajneesh Mohan Singh, the case of the petitioner was of invalid sanction, but after the statement of PW 21, it becomes a case of no sanction. It is argued that learned court below has wrongly interpreted the statement of PW 21, Rajneesh Mohan Singh, and has wrongly held that the sanction is legal. Learned counsel has also argued that the respondent has not only to prove that the sanction was given but prosecution has to establish and satisfy the court by leading evidence that the entire relevant fact has been placed before the sanctioning authority and the authority has applied its mind on the same, and that the sanction has been granted in accordance with law. In support of his contention, learned counsel for the petitioner has placed reliance on the principles as laid down in the case of CBI versus Ashok Kumar, 2014 within bracket 14 SCC 295. On the other hand, Mr. Ejaz Khan, learned counsel for the respondent, urged that PW 21, Rajneesh Mohan Singh, is not sanctioning authority. He is the person who has authenticated the sanction. He is under secretary in the ministry. He was asked certain questions in the cross-examination without showing the original documents which he wanted to see, as he has stated in paragraph number 12 of his statement. Therefore, a part of his statement cannot be construed to assume that there is no sanction to prosecute. Learned counsel further argued that any noting on the file has nothing to do with sanction for prosecution because notings are for internal matter and not for outside exposure. He referred to the principles as laid down in the case of Vivek Batra versus Union of India and others, within bracket 2017, 1 SCC 69. In paragraph number 14 of which, Honorable Court, inter alia, held that it tried to state that notings in a departmental file do not have the sanction of law to be an effective order. A noting by an officer is an expression of his viewpoint on the subject. It is no more than an opinion by an officer for internal use and consideration of the other officials of the department and for the benefit of the final decision-making authority. Needless to add that internal notings are not meant for outside exposure. It is argued that the text is to be tested in context and not in isolation. The competent authority has accorded sanction for prosecution. Therefore, there is no irregularity in the order passed by the learned court below, and the petition deserves to be rejected.